Can you hear me okay? Good. Paul, are you ready, my friend? We're streaming this for the benefit of those who couldn't be here on such a nice day this morning, so. All set, Paul? Great, great. So, pleasure to be here this morning. And hopefully you might learn a little something. Usually on these presentations, I have to waste time introducing myself. Well, I certainly don't have to do that with you folks. You're all friends and fellow church members here at First Lutheran. And a lot of you, I've already done estate planning for you. And you know, many of you have included your church in a very significant way. And I'm honored to be a part of that process. That makes me feel good as well. So I thank you for that. So I don't want to just talk at you this morning. You know, this probate stuff, it's kind of complicated. There's a lot of misunderstandings, a lot of misconceptions. I'm going to try to demystify it a little bit for you this morning. But if you don't ask questions, I get the impression that it's just going. So I'm asking you to interrupt me whenever you feel that it's necessary. Just raise your hand and I'll try to get to your questions. So, most people don't have a will. Statistically, most people don't have a will. Now, is that a bad thing? Maybe not. If you don't have a will, the state of Wisconsin sort of kind of has one for you. It's called the Laws of Intestate Succession. Oh, all right. Who gets it? Your next of kin. All right, who's that? Well, unless you've been married previously and have children of a previous marriage, that complicates things a little bit. But unless you're in that category, who gets it? Your spouse. Well, that's okay. What if you don't have a spouse? Then who's next? Your kids. Well, usually that's okay too. What if you don't have kids? Believe it or not, then it's your parents. It's not your siblings, it's your parents. And your parents might be quite elderly and they might be this close to going to a nursing home. So that might give you some cause for concern and time for a will or some other estate planning. So if there's no spouse, there's no kids, there's no parents, then it goes to the siblings. All right, what if one of your siblings predeceases you? They don't just drop out, it goes to their kids. So if you've got 3 siblings and one of them predeceases but has 2 kids, well, there's 3 equal shares, but the deceased sibling's children or issue get his or her third. So now, if that's what you want anyway, do you really need a will? Maybe not. Is it still a good idea to have one? Yeah, it is. Because if you have a will, you get to pick who's in charge. We call that a personal representative. We used to call it an executor. It's the same thing. But you get to pick who's in charge. In the absence of a will, the judge decides. And he might pick somebody good, but then again, you know, he's the judge. And it's entirely up to him to decide who's in charge. In addition, whoever the judge picks would have to be bonded. A bond is like an insurance policy that the estate would otherwise have to purchase. And like any other type of insurance, you have to pay a premium. It's not cheap. And the only coverage that you're getting, if you want to call it that, is coverage against the personal representative stealing all the money and going to Mexico or something like that. So if you have a will, you pick somebody you trust, and then in the will you put he to serve without bond. That's kind of a message to the judge, and what it means is, Judge, I trust this person, so can you waive the bond. And then as long as they're a Wisconsin resident, judges always do that. Question, yes.
Okay, if you have a will, do you have to go through probate or no?
Great question. The question was, if you have a will, do you still have to go through probate? Thank you. That's exactly where I was going. That's what wills are all about. So I'm going to back up a little bit. People think that they go to a lawyer, spend a lot of money, have a fancy will drawn up, and they think, okay, the will controls everything. No. No. If there's one thing that I hope you all take away from this morning, the will is what I refer to as the default. Yeah. So the will controls solely owned assets. In other words, the assets are in your name. They're not titled to a trust. We'll talk more about that later. And they don't have a beneficiary designation. We'll talk about that later too. So it's a solely owned asset with no beneficiary designation. The will controls those. Now, if you have to use the will to transfer anything, that's not automatic. No. I have to file the will with the court. In other words, a judge can look at it, make sure it complies with all of the necessary elements of Wisconsin law. I have to give a notice to the interested parties, all of your next of kin, all of the people named in the will. I have to give them official notice. I have to put a notice in the newspaper. That's mostly for the benefit of creditors. So see, now you're going down that probate path. Now, is that necessarily a bad thing? Not really. You've all heard the horror stories about, well, if it goes through probate between the lawyers and between the government, you're going to lose half of it. Now, I'm not going to say that never happens, but when it does happen, it's for one of two reasons that don't apply to anybody in this room. Reason number one, you have disinherited one of the kids and they don't like it. So what happens? They contest the will. Everybody lawyers up and it turns into World War III. But whether you disinherit them in a will or in a trust or in beneficiary designations, they have the same right to challenge that. It's just that it's a battle on a number of different fronts as opposed to a battle against the will only. So no real significant difference there, to be honest with you.
What would happen, like, let's say you had your children and you didn't want someone to be on it, and you said, in the will, I leave them $1.
Question for the benefit of our streaming audience, can you leave them $1? That's the legal equivalent of a disinheritance. We used to do that a lot, not anymore. You know why? I could never get them to sign the receipt for their dollar. And it made it real hard, to close the estate because I couldn't get a receipt for the dollar. Imagine that. So no, we just put it right in the will. That's important that the will be properly drafted. What Julie and I generally do is we have a provision that says, I know I've got this other child. It's not that I've forgotten about him, but he didn't get anything. And it's not due to lack of love or affection. We all love our kids, even if they don't do good things sometimes. It's not due to lack of love or affection, but it's also not the result of coercion, undue influence, things of that nature. We kind of tick off the legal grounds that they might otherwise have to challenge the will and get rid of those right from the get-go. Yeah, excellent question. Now, the other reason where probate expenses can get quite high, every once in a while when my clients die, they owe a lot of people a lot of money. That's actually one of the good things about probate is that there's a system for barring claims of creditors. It's supervised by the judge, and the law sets a deadline for creditors to file claims. And if they don't file a claim in proper form, before the deadline, they're out of luck. They can't come back to one of your kids a year later and say, well, you probably didn't know this, but your dad owed me a poker debt, and I never got paid, and you got the money, and, pay up. Can't happen in the context of a probate. But, every once in a while, we do get estates where there are a half a dozen creditors that have filed claims in proper form before the deadline. And under those circumstances, it takes a lot of my time. It's kind of like me defending a half a dozen lawsuits under the umbrella of one probate file. Yeah, it takes a lot of my time. My final bill is way higher than what I would like it to be. It's really complicated too if the government is one of those creditors, because the government makes the rules and they are what we call priority claims. So that can complicate things too. You guys don't owe anybody anything, so there aren't going to be any claims filed. Maybe you got a mortgage against the house, but those always have to be paid. There's no question about that. Those are never contested. If you don't pay the mortgage, you lose the house. Well, we're not going to let that happen. So it doesn't apply to you folks. Now, if it's a really simple probate, Julie and I call that a quickie probate, also known as an informal administration of the estate. There's no judge involved. It's a lot of paperwork. You still got to do a lot of paperwork, but it's paperwork that we file with the register in probate. And there aren't any contested issues where we have to bother a judge. But there's still some time and some expense associated with probate. So now that you know a little bit more about probate, is it still worth it to avoid probate? Yeah, I think it is. And what are the best ways to do that? Well, most lawyers recommend these fancy revocable trusts. Gotta be honest with you, those are a little oversold by my profession. We lawyers make a lot more money doing fancy trusts than we do keeping things simple. They work, they do. But in order for them to work, instead of a simple 2-page will, you've got a 20-page legal document. How many people really take the time and make the effort to read it through carefully and understand all of that legalese? Not a lot. They try, they get to page 2, but their eyes glaze over, and it's like, I'll do this some other time. And they never get around to it. And then they die. And then I've got the kids in my office, and I'm trying to summarize this more complicated legal document. And more often than not, what I'm hearing is, well, that's not what Mom and Dad wanted. And I'm like, I'm very sorry to hear that, because that's what this legal document says we're supposed to do together. The other problem that we encounter very frequently, people neglect to retitle all of their assets to their trust. That's how they work. People die, trusts don't. So you must, if you have a trust, you must retitle all of your assets to your trust. Remember that. And that's where a lot of people screw up. They either neglect to retitle something, or they acquire new assets. I see that all the time. They'll be driving around in northern Wisconsin. Wouldn't it be nice to have a cottage on a lake? Boy, the grandkids would love that. There's a for sale sign. Well, the realtor doesn't ask them, do you have a fancy trust? The realtor says, what's your name? I have to put it on this offer to purchase. Okay, now they die. Now I got the worst of both worlds. I've got some assets properly titled to the trust, and so therefore the trust controls those, not the will, the trust. But oops, I've got the solely owned cottage up north. And then I have to use the will to transfer the cottage into the trust where it should have been to begin with. And remember, anytime I have to use the will to transfer anything, that's not automatic. See, now you're going down that probate path. Hopefully it'll be an easy one, but then again, you never know. Jim, you had a question.
Yeah, does this apply to cars too?
Cars. Jim, great question. Actually, not so much. I never have to do a probate if it's just a vehicle. Why? Because the motor vehicle department has their own rules. And they basically want somebody to come in, any heir, somebody to come in, sign their form that says, I'm an heir, trust me. More importantly, write a check for $169.50. And if they do both of those things, they walk out of there with a new title that's in their name. So don't worry too much about titles. Yeah. Good question though, Jim. Thank you. All right. So those are revocable trusts. Now, is there an even? They work. By the way, if you have a trust, great. Keep it. Get a little more mileage out of it. But just understand how they work. Question in the back.
Yeah,
That's correct. Mike says, well, if there are creditors, do they all get paid before there's any distribution to the heirs? And the answer is absolutely. And in fact, in the context of a probate, there's a judge who insists that the file not be closed until all of the claims have been satisfied and receipts have been filed. Great question. Any other questions along those lines? Yes?
So then is a trust still going to go into probate?
Is a trust going to go into probate? No. No, not as long as you do it right. A trust will not go into probate. But, you know, understand that there's still work that has to be done. In a probate, it's done by the executor, what we used to call an executor, now a personal representative. With a trust, it's a trustee. But it's kind of the same stuff. You know, you've got to gather the assets, you've got to inventory them, you've got to liquidate them, you've got to pay all the bills, you've got to file all the tax returns, you still got to get, you know, permission from the taxing authorities, and then you close it out. With a trust, there's no judge supervising the process. There's no judge that's imposing deadlines. So, but other than that, the procedure is still very similar in both instances. Pastor.
How much money can you give to your children annually so that it's theirs and you die and
Yeah, the question was, how much can you gift to your children annually? That's a little off topic, but I'm going to answer it anyway. You can gift whatever you want. You can. There really is no limit. There is a requirement, however, that if it goes over a certain amount in a calendar year, you're supposed to tell the government about it. You're supposed to do a gift tax report. That doesn't mean that there's a gift tax to pay. And that amount, by the way, started out years ago, $10,000. They have now indexed it for inflation for 2024. It's up to $18,000. So you can, if you got 20 kids, you can give $18,000 to each of them and get rid of $360,000 out of your estate. I'm not recommending that, but can you do it? Absolutely. You're just supposed to file a report, that's all. Tell the government about it. And that goes way back because that's the way that people used to avoid the federal estate tax. They would give it all away before they died so that when they died, they were under the threshold. And back then, boy, the threshold was $675,000. And I had a lot of clients who got hit hard by that. And that was kind of a killer tax. It started out at like, I don't know, something like 35% and could rise as high as 55%. Especially my farming clients, you know, their net worth was well in excess of $675,000. But All the farmers I know, they don't have much cash. You know, they've got assets, but they don't have much cash. So those were sad days when we used to have to break up family farms to pay the federal estate tax. Well, as we speak, if you're a husband and wife, the threshold now, forget about the 675, the threshold now is upwards of 26 million. Yeah. I don't see anybody here with a net worth in excess of 26 million. If there are any, give me a call. We're going to do some fancy estate planning for you. But anyway, okay. Is there another option then, other than the revocable trust? Yeah, and it's probably what most of you are doing right now. Beneficiary designations. If you're a husband and wife and you own everything in joint tenancy, actually we have a different name for it now here in Wisconsin. It's called survivorship marital property. Same thing, really. But if everything's in joint tenancy, that's kind of like a beneficiary designation, and it all goes to the surviving spouse by operation of law. But the will has nothing to do with it. So if there's one thing I hope you take away from this morning, it's this. Beneficiary designations trump the will. They do. Those of you that have Thrivent policies, you have a beneficiary designation. I know you do. So when you die, Thrivent does not want to see a copy of your will. That's probate. They don't want to get involved in that. You know, they've heard about will contests. They don't want anything to do with them. So they get to look at their own records, and it's like, here it is, beneficiary designation. They get a death certificate, they mail out checks, and it's just that simple. And nowadays, you can do a beneficiary designation on essentially anything, even real estate, believe it or not. You know, my own parents never had a fancy revocable trusts. When my dad was diagnosed with cancer, of course, you think about these things more, and so he came to me, and he said, well, you know, all my colleagues have these fancy revocable trusts, and last I heard, my son was still a lawyer, where's my trust? And I said, well, Dad, everything's in joint tenancy with Mom. There isn't going to be any probate when you die. And he was like, you know, one more thing he could kind of cross off the list. So, okay, Dad went to heaven. Now everything's in Mom's name solely. That's a probate asset. Now, my parents were not wealthy people by any means. If you're going to amass a lot of wealth on this earth, probably being a Lutheran pastor is not the way to do it. But they had a house, and the house was their most significant asset. And what I was hearing from my mom is, oh, Dave, I love this house. You know, I'm going to live here until the day I die. And I'm like, well, great. You know, with the help of us kids, we'll make that happen. But that's a probate asset. And so then I was considering doing a trust for my mother. But then the Lord's plan became more apparent for her. A couple of months later, what I was hearing was very different. It was like, you know, Dave, this is a big house, and I don't like relying on you kids to mow the lawn and shovel the snow and clean the gutters. Actually, it was my brother Dan that was doing most of that. So the house got sold. And then we did this. We took the sale proceeds of the house and put it in an investment account, consolidated everything in one investment account, and we made that investment account TOD to the 4 kids. TOD is transfer on death. Yeah. So when Mom died, I didn't have to do a probate. I didn't even have to administer a trust. I mailed in 1 death certificate, and they mailed out 4 checks. And it was essentially just that simple. Now, that doesn't mean that it's going to be that simple for all of you, but there is that possibility. Mike?
So, and
also do it.
Exactly. Mike makes a very good point. Could I have done a TOD on the house? Let's say she wanted to hang on to it. Could I have done a TOD deed on the house? Yeah, in Wisconsin, absolutely. Not all states allow that. Wisconsin does. And it's very simple and it's very effective. I do a TOD deed. I was actually one of the first ones to record one of those in Walworth County back when they first passed that special law, and I had to devise my own form back then. Well, now they've become quite common. It's to the point where the State Bar of Wisconsin has their own official form. And once the State Bar adopts an official form, we lawyers all have to be slaves to it. I think my first one was better, at least okay, but we all use the official form now. So yeah, we do a lot of those. Very effective, but be careful. They work, but what if the kids don't get along? Yeah. What if there's 4 kids and they don't communicate well? What if 2 of them want to sell it and 2 of them don't? What if they finally decide, oh, I guess this is something we're just going to have to do together? One of them wants to hire this realtor, one of them wants to hire that realtor. One of them says, oh, we don't need a realtor, we can do this ourselves. What if, heaven forbid, they get an offer, 3 of the 4 kids want to accept it, one of them says, nope, I'm holding out for more money. Then you need a trust. Yeah, you do. And then you need to retitle the house to the trust, and that trustee would be a disinterested third party. It wouldn't be one of the kids who can, kind of lord it over the other 3. It would be a disinterested third party who would probably listen to all 4 of them and then say something like, well, I can see where I'm not going to be able to make the 4 of you happy. I'm not going to make anybody happy. This is the way it's going to be. But at least the job gets done. At least it gets done. Question?
And there's one child that you're executor that you totally trust and know everything you get put with it. What if you had done on your second account, savings account, and your home owner that they were also an owner with you?
I see.
Does that have to go over the probate if that person has done everything?
Good question. Not uncommon. Basically, the question is, there's kids, but I trust one of them to do the right thing, and so I'm going to put the house in joint tenancy with them, or I'm going to take this account and make them the POD beneficiary, or put the account in joint tenancy. And as long as they do what you want them to do, it works great. But then again, you're putting them in the position where after you die, they could say, yeah, mom loved me more. She really wanted me to have this money. So if I were you, I would couple it with a letter of instruction. At the very least, I would couple it with a letter of instruction and have that person acknowledge that they're receiving this account, but it's just, we call it a convenience account then. It's so that they have immediate access to the money and they can use it to pay your funeral expenses, pay your expenses of last illness, and things of that nature. And oh, by the way, if there's any money left, I understand I'm supposed to divide it equally with my siblings. But that's not uncommon, and a lot of people do it. Yeah, you can make it work. Yes, sir. Yeah, the question was, could there be a problem if the executor is out of state? And the answer to that is, yeah, there could be. And the reason for that is that our Wisconsin judges do not have jurisdiction over them. So let's say they live in Illinois across the state line. Well, if they're not doing their job right, they're not filing their inventory on time, they're not closing the estate on time, the judge can force them to come into court and answer to the judge. Well, if they're in Illinois, the judge has no authority over that person. So, then if they're bonded, the judge's job is real easy. He sends notice to the bonding company, and it's the bonding company's problem if the personal representative isn't getting their job done in a timely fashion. Now, that doesn't mean you can't name that person. You can, but the other heirs might have to consent to them serving without bond, or something like that. Yeah, great questions. More? Mhm. Great question. So they came in for appropriate estate planning, but then they acquired another house. Do they have to come back to the lawyer if they acquire a different house? And the answer is no, absolutely not. But they do have to pay attention to how they title it. So as long as it's titled in the same fashion, there's no problem. So again, if they're married, husband and wife, on the title it should say husband and wife as survivorship marital property. If the old deed read that way and the new one reads that way, no problem. Don't have to call Dave. The same title, you're okay. Now, let's say it's solely owned and you had a TOD beneficiary designation on the previous house. You gotta do a new one. Yeah, because the old one went poof on the day of the sale. That only applied to that property. That's specific to the property that is legally described in the TOD deed. So if it's solely owned, yeah, then you got to give your lawyer a call and you got to do a new TOD deed on the new house. Mention that to them. Question in the back. Yeah, let's say you did it the informal way. The question is, who gets the letter of instruction? You want to do it the simple way. You trust a child. You're going to put an account in joint tenancy. Who gets that letter? Well, not a bad idea to drop a copy off with your lawyer. I'll tell you that. And you might want to make the other kids aware of it too, so that they're aware and they don't misconstrue after you die. So thank you for that. Pastor?
Does the letter have to be notarized?
The letter does not have to be notarized. It does not. It just has to manifest your intent. I mean, I'm not saying it might not be a little better if it's witnessed or notarized, but from a legal perspective, does it have to be? No. Wills do. Wills have to be signed in the presence of two disinterested witnesses for it to be an effective will in the state of Wisconsin. We also do we attach an affidavit to our wills too that makes them, we call it self-proving. So if you also have the affidavit, when you die, you don't have to go find the witnesses who might be dead or gone and bring them into court to say, oh yeah, I remember now, they signed it in my presence, and no, they were thinking clearly that day. There wasn't anybody with a gun to their head saying sign here. It was not a product of coercion or undue influence or anything of that nature. Which, by the way, every state kind of does things a little differently. So some of those online wills, you pay a little bit of money and you get an online will. Ooh, I'm not really recommending those. There's too much at stake. You're better off going to an experienced estate planner and making sure that it's done in full compliance with Wisconsin law. Getting some great questions here this morning. Any others? Yes. Mm-hmm. Yeah, long question. I'll summarize it. So she knows someone, father owns the house, daughter is taking care of the father, father has Alzheimer's. Will she get the house? If dad did a will before he developed Alzheimer's, yeah, absolutely, the will is still totally valid. If dad did a TOD deed before he was afflicted by Alzheimer's, absolutely no problem. If he doesn't have a will, remember it's going to go in accordance with the laws of intestate succession. So if there's more than one child, is there? Or is there just the one child? If it's just the one child, it shouldn't be a problem. But if there's two kids and dad really wanted it to go to the one daughter, it might be too late. One of the things that Julie and I are very proud of is we have never had one of our wills successfully challenged because we're kind of careful about how we do things. So when we have a client come in who we know has Alzheimer's, we generally send them to their doctor for an evaluation. And then they have the evaluation, and if the doctor says, yep, my client has this problem, but, it hasn't reached the point where they can't understand, who the objects of their bounty are and the nature of their estate. And so the doctor says, yeah, he still has sufficient capacity to sign a will. Then we do the will the same day. So they visit the doctor in the morning, they come into our office in the afternoon, and we get the job done that one. But, okay, I'm going to, we have time left. Wonderful. I'd like to redirect this discussion a little bit then to what are the best ways to include the church in your estate. So let's talk about that a little bit. And nowadays, probably one of the best ways is with beneficiary designations again. What I see a lot now, in the old days, you used to have a pension. You'd work for 30 years and you'd have your retirement party and get your gold watch and you'd have a pension for the rest of your life. Boy, those days are gone, huh? So nowadays, most wealth is in the form of IRAs, 401ks, 403bs, shepherd plans. Those are taxable to whoever receives them. Whoever gets them, they have to pay tax on it. And it used to be that you could roll it over into an inherited IRA, and then that person could choose when they want to pull the money out. In other words, they could postpone it until they retire. Well, the government does what the government does. They change the rules of the game, and at least for your kids, they have to pull it out within 10 years. They have no choice. They have to pull it out within 10 years. Spouses, no worries there. Spouse can still roll it over and pull the money out anytime they want, all the way up to the date of death. Not so much with kids. And my experience is that when dad dies, they're in the height of their earning capacity. They've established themselves in their careers. They're in probably the highest tax bracket that they're ever going to be in, and now they have to pull money out of this IRA in addition. So, solution? Give it to the church. Churches don't pay tax. So you give the non-taxable stuff to the kids, and you give the taxable stuff to your church. And remember, you can do it with a beneficiary designation. Now, I'm going to take that even one step further. I know First Lutheran is very near and dear to all of you. But you might have other church organizations that appeal to you as well. Maybe you were the product of an adoption by Wisconsin Lutheran Child and Family Service, and now you want to remember them in addition to your church. Or maybe some of you are now enthused about Time of Grace. We have all these, we call them parasynodicals, and they appeal to a lot of people. There's a nice solution to that thanks to our synod. You name the WELS Foundation as the beneficiary, as the sole beneficiary, and then you give the foundation a letter of instruction. So if you've got, let's say you've got 10 charitable beneficiaries that you want to include. Maybe the church for 50%, but then you've got a bunch of others for smaller percentages. If you go to your IRA administrator and you want to list 10 beneficiaries, they're going to say, we don't do that. That doesn't comport with our policies and procedures manual. You know, they like to invest your money, but they're not real enthused about helping you achieve your estate planning goals unless it's easy for them too. And 10 beneficiaries is not easy for them. You're not going to get their cooperation. But if you go in and you say, one beneficiary, no problem. So, okay, what happens then? You die. Wells Foundation gets a check. Lord be praised, we got a check. What do we do with it? They check their records. There's the letter of instruction, and they take that one check and they divvy it up amongst all of your beneficiaries. It's gotten even better. You know, some people, maybe it's not just their church organizations that they want to remember. Maybe it's, I don't know, the American Cancer Society. Wells Foundation will help you with that too. I mean, they're primarily there to assist the church, but they understand that a lot of their people want to include people who are not part of our church. That's okay. So as long as the total to the non-Wells organizations is less than 50%, they're happy to help out. They are. Yeah, so kind of keep that in mind. Bonnie. Oh. Yeah, question is, can you designate it for mission work or for a Lutheran high school? Absolutely you can. Yeah, and that is encouraged. You can either put a little something about, you know, what you want to use it for. You know, so you can give it to Wells, but you can say, yeah, here's your check, but I want it to be used for world missions, which is part of Wells, obviously. Yeah, you can do that. In our own plan, Bonnie and I did our letter of instruction, and my dad my dad and mom have a scholarship fund at the seminary, and so we designate that. So does Bonnie's parents at Michigan Lutheran Seminary. So we just included that on that line, you know, to be used for. Real simple, very effective, very effective. So give that some thought. Now, lastly, why do we have to wait until we die to give generously? You know, the Bible talks frequently about the joy of giving. Well, experience it now. You know, why? When you die, you can't be any more joyful in heaven. You don't need it then. So think in terms of maybe doing something now. And here, you know, I see a lot of people that are my age. Boy, we're old, aren't we though? For people that are more than 70 and a half, there's a couple of really neat devices out there that I'm going to recommend to you. One is called a qualified charitable distribution. Qualified charitable distribution. In other words, it comes out of your IRA. So your IRA, remember, is going to be taxable to you. So when you pull that money out, you got to, unless it's a Roth IRA, a whole different thing there. So I don't have time to get into all that. But ordinarily, it's going to be taxable to you. But the government says that as long as you're at least 70 and a half, you can do a qualified charitable distribution out of that account. And it started out at $100,000 total. Again, indexed for inflation, so 2024, it's now up to 105,000. I'm going to give that a try myself with regard to his Enter His Gates program, and I'll let you know. I had one discussion with the guy, and he says, yeah, we do that all the time, real simple. I'll send you the form. Just got it the other day, one-page form, but the check has to go directly to the church. Can't have your name on it. See, if it has your name on it, then it's taxable to you. You're the name on the check, and then you get a 1099 at the end of the year. So the check has to have the church's name on it. It does. But they'll mail the check to you so that it can be proudly presented to your church along with specific instructions as to how to use it. So if I want to designate it for Enter His Gates, I do that. Yeah. Boy, Barney, you are right on top of things. Barney says, does that satisfy the minimum distribution requirements? Yes, it does. Please understand what these minimum distribution requirements are. You know, the government basically says, you know, we've been waiting too long for you to be paying taxes on this money. We gave you a tax break when you put it in, and you've never paid any taxes on it. And doggone it, we're going to make you start paying taxes. So the age used to be 70 and a half. That has now been bumped up to 73. So when you get to be age 73, you must take what's called a minimum distribution, minimum annual distribution. Can you have that check go directly to the church in the form of a qualified charitable distribution? Yes. Yes, and that meets all of those requirements.
I like to use the qualified charitable distribution. There's a huge difference in our real estate, not our federal income tax.
Yeah.
Amazing.
Yeah. Thank you for that, Jim. Jim has utilized that and found it to be of great benefit. And it can be a benefit on a number of different levels. You know, most of us are familiar with, they call it bracket creep. You know, the more you make, the higher the percentage gets. But there's kind of some hidden penalties too. You know, like for us, we have to pay a Medicare premium. And if you're under a certain income level, it's not all that bad. But boy, once you get above a certain amount, 2 years later, your Medicare premium is going to skyrocket. Yeah. So that's another reason to try to keep your adjusted gross income down in a manageable level. And, you know, the other way to do that is to itemize your deductions. See, with what I'm describing now, you don't have to itemize. It's just never taxed to you. Nothing simpler than that. In the old days, most people itemized. More than I think 2/3 of people itemized. But that was the old days. And then they changed the tax laws and they increased the standard deduction. I think the most recent figures that I've seen is it's only like, I don't know, maybe 15% of people itemize their deductions. Because the standard deduction is well above 20 grand. Well, not enough people give more than 20 grand to their church every year. So the solution to that is bunch your deductions. Bunch your deductions. So you kind of like prepay your church giving for the following year in 1 year. And there's a great device to accomplish that. It's called a donor advised fund. So you write one check to the Wells Foundation and they put it in your donor advised fund, and then they do it all for you. The way Bonnie and I have it set up, you know, we're gone a lot now, you know, here, there, and everywhere. So we don't see you guys on Sunday mornings as much as we'd like to. Doesn't mean we're not in church. We're just not in church here. But we don't have to worry about our giving anymore because it's all automated. It comes right out of our donor advised fund. In the old days, remember when we all used to use the box of envelopes? And we'd get back and it's like, oh man, we haven't been in church for 3 weeks. And I'd have to write a big check and play catch up. I don't have to worry about that anymore. If we want to go places and do things, we know that our church giving is on autopilot. Works out very well. But at any rate, you get the one deduction when you make the big donation to your donor advised fund. Again, there's more information on that at the Wells Foundation. In fact, Fred and I did a little video for him. So if you want to see that, go to Wells Foundation and type in donor advised fund, and I guess you're going to see my mug on the little podcast that they have if you want more information. Questions? Yes. Yeah. Bill makes a very good point. He did that where he had his minimum distribution directed to the church 1 year. he kind of thought maybe they would do that every year. Oh, no. You know, they have to, it's a year-by-year thing. It is. You have to contact them every year, or they're going to put your name on the check, and as soon as they put your name on the check, it's too late to do anything about it. It's going to be taxable to you. So you do have to stay on top of it. But you have to stay on top of everything. You know, even your estate plan. You really should have that reviewed periodically. One thing Julie and I do, we call them free will checkups, where if the client wants to come in every 2, 3, 4 years, and we just review what they have. If there's no changes, there's no charge. We're happy to spend a half hour with you and say, good work, keep it up. But old wills are good wills, you know, but you should review them periodically and just ask yourself 2 very simple questions. Are these still the right people getting my property? And then question number 2, are these still the right people that I'm putting in charge, you know, to make sure? And if the answer to both of those simple questions is still yes, old wills are good wills. You know, they don't have an expiration date. Keep using them. If you move to another state, they're honored there as well. No worries there. Although if you do move to another state, I don't know if I have a lot of time to go into this in great detail, but there are 2 documents that everybody should have in addition to a will or a trust. Those 2 documents are a financial, or we call it durable, power of attorney. That has to do with your financial affairs. You're not dead, but you're laid up for a period of time. And you need somebody to pay your bills, sign your tax returns, things of that nature. If you don't have one of those, then a judge has to appoint a guardian of your property to do that stuff for you. Believe me, you do not want that. The second document, probably the most important, health care power of attorney. Health care power of attorney. Everyone needs one of those. You need to use your state's form. Yeah. You know, we really need a federal law that says one form, good in all 50 states. That makes way too much sense. That will never happen. So instead, you've got 50 different forms. And if you're not using their form, they get nervous. I've had one of those calls. Well, this isn't our Illinois form. We're not sure we can honor it. It's not our Illinois form. So Julie and I put a special provision in our healthcare powers of attorney now that address that. So that, you know, we can say, oh, well, take a look at page 4, number 4, special provisions. This is the legal equivalent of your Illinois form. So the answer is yes, you can honor it. And you better honor it. And if you still feel otherwise, going to need a call from your legal department within the next 5 minutes. Never gotten that call. So, but that's an extremely important document. You know, medical science being what it is nowadays, if they put you into intensive care and hook you up to enough of their machines, they can pretty much keep that heart pumping as long as they want to. And in the absence of one of these documents properly drafted, they really are legally obligated to use what's commonly referred to as heroic measures to keep people alive, even if there's no realistic expectation that you will ever lead a meaningful existence. So, yeah, make sure you got one of those. Yes? Question was, in a will, what does the term residue of my estate mean? Isn't that puzzling? I mean, you think like you're giving your kids garbage, the leftovers. They only get the residue. No, what that means is it's a term of art. And what it means is you pay the bills first, you pay the expenses of administration first. Guess what? The lawyer has to get paid, and the personal representative has to get paid. And then whatever's left is commonly referred to as the residue of your estate. Yeah. Not much. So the question was, well, what if you did a specific bequest, let's say, of your home to your kids? That's taken right off the top then. So first you pay the bills, and then actually you're correct. The next are the specific bequests. Those have to be honored. And then it's only what's left after that that is the residue. Sometimes we run into problems because there's not enough to go around. So if there's specific bequests, sometimes, let's say you got 5 different specific bequests. You want this person, this person, this person, and this person to get $10,000. Well, then sometimes they all have to take a haircut to the same degree. But there's rules and statutes that govern how we go about apportioning specific bequests under those circumstances. Well, I think we did it. You're very welcome. Pastor, could you close with prayer? Can I ask you to do that?
Okay. How about singing the Commandant?
There you go.
Praise God from whom all blessings flow. Praise Him, all creatures here below. Praise Him above, ye heavenly hosts. Praise Father, Son, and Holy Ghost. Amen.
Thank you.